Good morning, coffee drinkers. I'm Hallie Zobel, and welcome back to Law Moment. I'm a probate attorney located in Orlando, Florida, at Private Corporate Counsel. Today's question is, does a will mean the estate does not go to probate? I'm a probate attorney, as I've said, and I get asked this question weekly. A friend's mother recently passed, and this friend asked me the exact question. I believe I've discussed this in previous other law moments, I'm sure, but it's so important I'm going to revisit it. A legally drafted, valid last will and testament does not mean that there's no probate. This is a common misconception. I've had families get angry with me, stating that they thought their mother's will meant that no one needs to go to probate court. I don't know where they got this information, and the family may not know due to client confidentiality, but I've discussed this thoroughly with my client and advised her what happens at her death. I don't know where this nonsense started, but it didn't start here. I have no way of knowing, should you call me, if a probate is necessary until I meet with the designated personal representative or executor, as you may have heard the term, and have answers to multiple questions. It's answered by knowledge of the assets that the decedent own and how these assets are titled. So, in essence, it all boils down to titling of the assets. For example, if mother owned a house in her name, then there will be a need for a probate action to get the house transferred to the rightful owners named in the will. You cannot just file the will at the clerk's office in the county where your mother lived, cross your fingers, and hope it's transferred to other people's names. It doesn't work that way. In Florida, in most instances, you must have an attorney to go through the probate court. And not every state is like this, and other states may allow you to do it yourself. If the bank insists you need a letter from the court, that means you must obtain an attorney and go through the probate court system to get a letter of administration appointing you as personal representative of the estate. Then you formally have authority to act on behalf of the estate. I know this can be confusing. I suggest you consult a probate attorney and discuss the various assets that your loved one owns to make a valid determination if the matter is to go through probate. I thank you for listening this morning, and coffee drinkers, keep your heads up and have a terrific day. Hallie Zobel, I can be reached at Private Corporate Counsel 407-647-7887. Thank you.